Good morning. Good morning. It's time for Disorder in the Courts live coverage of the ballerina murder trial, Florida versus Ashley Benefield. As we have been doing in the last few days, we're starting our stream on a little bit of a delay from trial. So we have the advantage of zooming past the dead spots. I've peeped in and looked ahead a little bit and noticed that Doug's daughter, Eva, is testifying again. So I'm not sure. We'll have to find out together whether the defense has already rested and the prosecution has already rested and the defense has called her again or what. But I have found some really interesting videos with interesting information for us to watch during breaks, including Eva's TikTok. So with that, let's get started. Please remember to hit the like button. Thank you very much.
All right. Do we expect to finish today with the state's case? Yeah. Come on in, ma'am.
Do we know which deputy reported the matter? Or any of the deputies in the courtroom that saw the conversation late yesterday afternoon? Do we know which deputy it was?
As I said, it was reported to me that some unidentified person told the deputy.
Okay, so just one moment.
Are you the one that they told? Yeah. Okay, right here. Mr. Taylor. Apparently it was reported to Deputy Racky.
I have a moment with the deputy.
Of course, State, you want to be present?
Rebuttal witness. The state requested that you remain as a potential rebuttal witness.
Correct.
Morning.
Now, what did you think Judge White's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
All right. Did you realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us if you would. I'm just trying to get an explanation. Tell us if you would what you were thinking that.
Objection.
Overruled.
That's not what she said.
We're figuring that out.
What you were thinking that you felt allowed you to do exactly that which Judge White cautioned you not to.
I was caught off guard in the hallway when I was under extreme emotional distress after being here, hearing different testimonies about my father's murder. And when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you discuss with the reporter?
Just how I felt about the situation and who my dad's character was as I saw him.
When you say about the situation, you mean about the case, the trial?
Not about the trial.
What situation were you referring to?
My emotional state.
Okay. You post on social media?
I do.
So it appears that they've called it, the jury is not in the room. They have called Eva, Doug's daughter, for a hearing because it was reported that she gave a media interview. I also did find her TikTok, and I watched her recent TikTok videos. She does not talk about the trial at all. She only talks about she stays pretty safe, but I don't know what, she said to the reporter, but in these situations what happens is the defense is going to take any opportunity. She could have been interviewed about, what flavored tea she drank that morning, and the defense would still be calling her because she's a witness in this case and she was supposed to not talk, about the case. So anyway, yeah, I don't know. I'm not sure. Johnny. Sometimes it's a mystery to me, Johnny, what happens with my channel from a day-to-day basis. I'm serious. I don't know. I really don't know.
TikTok,
Yes.
any
Hey,
others?
Solo.
No.
Following your testimony here last Tuesday, did you make any posts?
I did.
Tell us how many?
3.
3. And tell us one at a time. Were all 3 of them on Tuesday afternoon, Tuesday evening?
1 was on Tuesday.
And when were the other 2?
Yesterday.
Okay. And tell us, as to the first post, what was it about?
I said that I testified.
Okay. And did you have anything to say about your testifying?
I talked about it being on live television,
Mm-hmm. What else?
that somebody back home was watching.
I assume you have copies.
So there's something I've been noticing recently with a lot of people who have been appearing in these court cases in courts, is they are very, 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 very conscious that it's going to be on live TV. And so I'm starting to have a whole other new line of thinking, not new, but branched off line of thinking about how, you know, these cameras in the courtroom incentivize people to get into court for fame. And I'm not saying this about this girl. She didn't ask for her dad to be. I'm saying this in general, about people. It's like, oh, goody, I get to be, and I'm not saying this about her. I'm saying this in general. I've seen this about other people. Oh, goody, I get to be a witness in a high profile case and I'm going to be on court TV. I'm seeing a lot of people who are witnesses in cases like this take it from that, view it from that perspective. And it's kind of disheartening, but I guess it's part of our judicial process now.
Copies on your phone?
I do.
You have your phone with you here today?
I do not. Not on me.
Where is it?
It's over.
We're finding out together what the issue is with the girl, but my understanding is that she talked to the media, and she's in a sequestration order. She's not supposed to talk to anybody. Meaning, like, she's just not supposed to talk to about the case in general, or make editorial comments about the case. But I haven't seen the comments that she made to the media, and apparently she was interviewed yesterday. So that's what this is. She's being asked about her interview yesterday and what it entailed and things like that.
In the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
Yes, sir.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Judge, I'm going to object if he knows clearly they have the list. So,
Well, I don't know.
It's an invasion of her privacy to dig into her phone.
Not if it's on social media, but we started off talking about just speaking with some reporter, and now we're talking about a social media post. If you've seen it and if she's violating the rules, let's just get it out.
Okay, I'm trying to find that out.
So so now it's a fishing expedition. If you know a violation, let's talk about it.
Right.
If not, let's just get moving. We got a jury waiting.
Exactly.
I understand that, Judge. How do I know? She's told us she posted 3 things. How do I know what it's about? What if one of them involved
You watch them.
discussions that were inappropriate?
I could show
How am
them
I
to
to know
you.
that? I've been a little preoccupied, and I don't do social media.
Sir, if you have specific evidence, let's talk about it. If not, you have a team. You've got 1, 2, 3 people in court right behind you. I don't know. Maybe they can look it up. But let's focus on what
I
we
watch
know
them.
about
They
as
do not
opposed to
cross any
digging
lines.
into speculation.
I have no further questions.
No question.
Nice try.
Ms. Benefield, when you had this conversation with the reporter in the hallway, were there any other witnesses around?
Yes. I'm sorry. Let me re-answer that question. None that testified. I think.
Okay, so you're saying there were people standing
There
around,
were people
but
around.
none of the witnesses in this case.
No, sir. Not that I remember.
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
All right. Do you have any follow-up questions to my questions?
No, sir.
Do you have any follow-up questions to my questions? All right, Ms. Benefield, you can step back out. Did you want to call any other witnesses?
No, sir.
State.
No.
All right.
I'll show you her TikTok later at a break. They're very benign. It's just a fishing expedition.
All right, Ms. Benefield's out of the courtroom. Go ahead, sir. Do you have any argument? You want to seek any relief? You want to argue in support of any relief?
Yeah, I think she violated the court's admonition that the court routinely gives to the witnesses. And as a result, again, I have no personal interest in seeing the young woman suffer, but I do think violation of the court's admonition is sufficient to strike her as a potential rebuttal witness.
Judge, I think you asked her the relevant questions. I think the questions that you asked her are the admonitions that you gave her as a witness, and she did not break any of those.
Final thoughts? I'm certainly distressed that, let me say first, the media policy for the 12th Circuit prohibits the media from conducting interviews inside of the courthouse. It is my understanding that our media and public relations person met this morning or was going to meet this morning with the media to go over the administrative order again, because certainly I think the media is and should be aware of that administrative order and comply with it. The specific incident that we're talking about after hours yesterday, the facts that are in front of me are not that Ms. Benefield spoke about her testimony or the questions asked. But I also have not heard from the reporter, and I have not seen any tape or footage. At this point, I'm going to reserve on the request, and I'll make a decision. If and when she's called again, I'll make a decision at that point. You just have to remind me if we get there.
I'm satisfied, Your Honor. Thank you.
All right, next.
Yeah.
Deputy, if you just
Wanted to
start, I don't care about the order, just start
Media
bringing in
does
the
that all
jurors
the
one at a
time.
time, please. At this point, I'm reserving on whether she can be recalled or not, but I think an admonition at this point is appropriate. Yes, Ms. Benefield could come in.
This court going to allow her to sit in for the testimony, knowing that she may be recalled. After the rule has been invoked.
Yes, under Marcy's. Sorry. No, hold on.
I think one of the reasons the judge has to admonish people every time they read the
All right, Ms. Benefield, you can stop right there.
Will do that.
Ma'am, the court has ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given and the importance of those. They matter and they need to be followed. Do you understand?
Yes, sir.
All right, ma'am, you can retake your seat. All right. No. Morning, sir. You can just grab this front chair, it's just fine. And can you remind me, please, what juror number you were?
33.
33. All right. Juror 33, the reason I'm going to bring the jurors out individually is that this morning, the court was provided a letter from a law firm representing a reporter who indicated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing you out to find out, did that happen to you? Have you received any information outside of these 4 walls?
No, I didn't go to a restaurant. I was actually at 8. It was in my car here in this building.
All right. State, do you have any questions?
No.
Hey, my
Defense?
company.
No, sir.
All right, thank you, sir.
So that's that explains what happened yesterday. Because I don't know if you remember, they had talked about a reporter coming in and wanting to report something to somebody, and then the defense attorney was like, "Oh, judge, well, they can come to me and tell me about it if they want to." They had no idea. I don't know if it's the same situation, but I guess they're saying that the reporter was talking about seeing people in a restaurant with things play with the trial playing.
Good morning, ma'am. Just grab that first chair. And could you please remind me which juror number you were?
15.
15. All right, ma'am. The reason I'm bringing about jurors individually is that this morning I was provided a letter from a law firm in West Palm Beach that claims to represent a news reporter. And the news reporter anonymously has stated that during the lunch break yesterday, the reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to talk about, have you seen any news coverage? Have you heard people discussing the case? Received anything outside of
So they're
this
going to
room?
do this
No,
with
sir.
every
I go
single
at lunch.
juror, huh?
State, do you have any questions?
No, sir.
Defense.
So they're going to do this with every single juror. Honestly, Johnny, I'm okay with that kind of snitching. The report, the trial needs to be fair. But I don't want to sit through every single juror, being asked the same question. So I'll probably fast forward through that. But I want to mention one thing real quickly. What you missed, Sparkles, was the daughter of the victim being grilled about talking to a news reporter, and they eventually, and also about posting on TikTok. I'm going to show her TikToks later. They're totally benign. There's nothing wrong with them. In fact, I think her TikToks are endearing. The other thing is, I guess, a reporter snitched on some jurors that they apparently saw in a restaurant where news coverage was being played of the uh, trial and commentary, and they were talking about it, and in the restaurant, and the reporter recognized one of the people as a juror, so she told the court through a lawyer. She or he told the court through a lawyer. So now the judge is calling in every single juror and asking them, did you see anything? Did you see anything? And they now, Teacup and Patricia, it looks like you might have already seen this part, because we are on delay, so that we could fast forward through some stuff. Is there any should I stop anywhere? Did any of the jurors get kicked out? Does he get through all these questions with all these jurors, and does anything interesting happen? Or can we get directly to continuing until after the jury comes in? It doesn't look like anything major happened, so I'm just going to go straight forward to when the jury comes in and the first witness. One guy admits he was there, got his food to go, and left. Interesting. Okay. One other thing I want to mention real quickly is it's just a reminder. It's just a reminder that you guys might have to actively look for my channel. Did any of you guys get a notification from my channel this morning about going live? Because, as I've said before, I'm pretty sure I'm shadow banned, and that's why I don't put as much energy into my other channel anymore. I'm shadow banned on both channels. I do this mostly oh, good. Okay, Teacup got the notification. Okay, it's a nothing burger. But I just want to make sure that just to remind people, it's good that some notifications are going out, but I just feel like I have to keep reminding people to find my channel. If you want to find me live streaming, you have to sometimes you have to remember me and actively type in my channel, because YouTube can't be depended on to actively remind you that I exist. So anyway. Okay. Well, I'm glad people are getting notifications. And I'm pretty sure, it makes sense that you'd all be getting notifications because you all recently came to my channel. And I'm pretty sure those are the only people who get notifications, are my regulars. You know what I mean? My regulars, and maybe a few new people who, they'll offer it to. They definitely have my channel suppressed. And, I don't know exactly how it works, but it's definitely suppressed. So let's keep going.
When we left off yesterday, the state was still presenting its case. State, call your next witness.
State calls Sergeant Brian Hewitt.
So this is a reminder, the state is supposed to today. The state is, and I've just turned down the volume as we wait for this witness to come in. The state is supposed to rest today. I very much hope that they are able to prosecute their case better today. When I watched Ashley Benefield's TikTok, I felt I had a much better idea of the situation in this case, but of course that's the daughter and she's gonna, she's gonna be biased. But anyway,
Just make yourself comfortable in that chair, get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. There you go. And if you just speak in a loud, clear voice right into it, it should be just fine. If we hear you breathing, you're too close.
Okay.
Good morning.
Good morning.
Please state your name and spell your first and last name.
Brian Keelis, BrianQuiles,
Where do you work?
Manatee County Sheriff's Office.
How long have you worked there?
About 19 and a half years.
What is your current position with them?
I'm the supervisor of the Technical Services Unit.
And you're, I don't know if I said this, you're a sergeant?
Yes.
Okay. And what is the Technical Services Unit?
It's a unit that gets involved in the technical aspects of criminal investigations. One of the responsibilities is downloading data from cell phones and analyzing that data.
Okay. And prior to your current position, what positions did you have at the Sheriff's Office?
Several. I started on the road, moved over to a cops unit. Eventually moved over to the Special Investigations Division as an undercover detective for a couple of years. After that, there was a position involved in, again, technical aspects of investigations. It just wasn't called the Technical Services Unit at the time. And that's until I did that position for a number of years until I was promoted, and eventually the Technical Services Unit started, and that's when I started supervising that unit.
And what training and education do you have to do your current position?
I've had probably over around 800 hours of various technical training, some related to cell phones, some related to technical surveillance, but roughly 800 hours of total training.
Okay. And I want to talk about specifically cell phones and how you deal with those. So how much training would you say you've had in cell phones and analyzing cell phones?
It's probably a third of that 800, so around 250, 260, something like that.
Okay. When you do what I call a forensic examination of a phone, what do you do? Just briefly.
It's really a case by case basis. There's each phone. It's somewhat of a research project. There's so many variables, but ultimately that phone will get plugged into a forensic workstation. Software would be used to be able to download or extract that data from that cell phone, and that same forensic workstation will use software to be able to decode or parse that data to be able to review it.
When you download, I call it dump, a cell phone, when you dump the information from a cell phone, is it voluminous?
Yeah, it can be. Yes, it's quite a bit.
Okay. And is it easy to interpret without help?
No, you definitely need a certain expertise to be able to look at it. You need software to make it a little bit more of a convenience to be able to look at it, but definitely need some assistance to be able to do it.
And do you have programs, software that helps you with that?
Yes.
What are the names of the ones you use?
Our main state program is Cellbrite. It helps us extract the data. If it needs to bypass encryption and bypass locks, it'll help us do that as well. There's other programs that we use, Gray Shift, excuse me, as well, to be able to unlock the data and extract it. We have toolkits that I like to refer to of data or of software to be able to use.
And give me a general idea of how many phones you've done this with.
Me personally, hundreds. I want to say the unit as a whole has steadily done 200 to 300 leading up to about 2002, and that has increased probably closer to about 500 devices for this year alone, I'm pretty sure.
Okay, so the unit 500 devices for this year.
Yes.
And when you use software like Cellbrite or Gray
Shift.
Does it allow you to put whatever data you want, for instance, pick out what you want and put it in an easily readable form?
You can filter the reports that the software displays, and if you only want it to include messages, you can create a report with just those messages. Sure.
So, for instance, on just your average cell phone, if you did a cell phone dump, you would get messages like text messages.
Yes.
And emails.
Yes.
internet searches.
Yes.
And all different things that would be on your phone.
If those data transactions exist on the phone, you will typically get those.
Okay. So this software allows you to pare that down to what you want.
Yes.
In the instant case where you asked to do extractions on 2 phones.
Yes.
Okay. And I'm going to show you what's been previously entered into evidence as States Exhibit 11 and 12. You can take a look at both of those. Can you tell me what those are?
These are the 2 cell phones that I had done examinations on. One of them belonging to Doug Benefield, the other one belonging to Ashley Benefield.
And is that the evidence tag that's on there? Do you recognize that?
Yes.
And does it have your information on it?
Yes, it does.
Okay. So did you go through the process that you just explained with both of these phones?
There were differences in the process, but they ultimately we were able to get a path to data and produce a report for that data.
Okay. And which one were you able to extract first?
Doug's phone, we were able to extract first.
Okay. And then were you able to extract data from Ashley's phone?
We were able to eventually. It did take quite some time.
Okay. Why did it take quite some time?
That phone, it was passcoded, or it had a PIN code. I want to say it was a 6-digit PIN code, and the software it took a long time to actually bypass that PIN, that encryption or that PIN.
Okay, so if you don't have the passcode or a way to get into the phone, your system can do that?
Yes, it varies in length of how long it could take to bypass, but yes, the system allows for that.
Okay, and you called one of those Doug's phone and one of those Ashley's phone. When you do extractions of the data, do you get information about identifying who owns the phone?
Yes.
And can you just explain what that is?
Yeah, a lot of the times, especially with iPhones, you'll have an Apple ID that could be associated with the person that owns a phone. In the contact information, it'll have the owner's information, so it's pretty easily identify who that phone belongs to, especially with iPhones.
Okay, and the one phone, I'm not sure if it's 11 or 12, that you said was Doug's phone.
12.
12. Did that have identifying information on it?
Yes.
That identified it as Doug's phone?
Correct.
And then for Ashley's phone, same question?
Yes.
Did you prepare a spreadsheet for this case?
I did.
And what is on the spreadsheet?
It was communication between Ashley and Doug extracted from Ashley's phone from September 20th of 2020 until September 27th of 2020.
Okay. And when you say communication, what do you mean?
In that particular report, it was mainly text messaging back and forth. There were a few phone calls, and I want to say at least one email, but mostly text messages.
Okay. And you said you prepared the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare that information was on his phone as well?
Yes.
Okay. And was it?
Yes.
I'm going to show you what's been marked as States Exhibit 98. You can tell me if you recognize that.
I do.
And what is it?
This is the CD containing the Excel spreadsheet that we just talked about.
Okay. And when you said there's communications between the two, if there were any attachments to those communications, would they also be in your spreadsheet?
Yes, they would. Yes.
And you looked at this?
Yes.
Yes. And is it accurate based on the spreadsheet that you created?
Yes.
Statement of evidence states 98.
Any objection to States Exhibit 98?
No.
Proceed.
So I'm going to publish the spreadsheet now. If we could turn down the lights and potentially, it's a little difficult to read, potentially shut the blinds. From where I'm sitting. I don't know if I have handed you an exact copy, a hard copy. So I don't know what is easier for you to read. I know that print is very small as
I'm
well.
sorry, Mr. Don. Can you approach for just a minute?
Sure. Are you going to read from the one in front of you or the one behind you?
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through what we're looking at. So I have a laser pointer for you. So the red button is yours. And I have one as well. I do want to talk a little bit about these attachments that are on the phone or on this spreadsheet. Are you able to tell when you look at one of these attachments where that image or picture or video came from?
It depends on each attachment. There could be metadata there that the attachment could have been from a screenshot. It could have been from the actual phone, taken with the actual phone. So it just, again, case by case basis.
Okay, so there is a video on this phone that, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about?
I'm not, no.
Let me, hold on one moment and I'll let you know which one it is. On your spreadsheet. Can you tell from what you're looking at where that video came from? Or do you recall from your investigation before where that video came from?
And based on what I'm looking at, it's an attachment from a text message from Doug Benefield to Miss Benefield.
Okay. And when you looked at Doug Benefield's phone, could you tell whether this movie was taken on his phone or sent to his phone?
I don't have a recollection of the actual metadata of the video itself
Okay.
on either phone. This is just looking at it from the attachment perspective, not the specific video itself.
Okay. If we could approach, Judge. The second column is what?
It's just the type of entry it is.
And give me a couple of examples of the type of entry that it is into the phone.
In this timeline, it's labeled as an instant message. If it was a phone call, you would see phone call. If it was an email, you would see email.
Okay. And what does instant message mean? Is that a text?
It's a text.
Okay. And then the third column is what?
It's the direction of that transaction. It's specifically dealing with messages, whether it's incoming or outgoing.
Okay. So that would be incoming or outgoing from Ashley Benefield's phone.
Correct.
All right. And then the next column?
It's whether or not that data transaction has an attachment.
Okay. And then the next column?
It's the date.
And the next?
It says time, but it also has the date and the time in the correct time code and time zone.
Okay. You said correct time zone. Can you explain that real quick?
So if you see UTC -4, UTC is what's considered standard time for world clocks. The time where the prime meridian is in the world, you subtract from that and you come up with a time code or the time zone that you're in. We are currently in -4. We're technically -5, but because daylight savings times, we actually subtract -4.
Okay. So does your software do that automatically?
Yes.
Okay. So when it says at the first line, it says 8:20.02, and that says UTC -4, that is the current Florida Bradenton time.
Correct.
Okay. And then the next column, and I made it bigger on the screen if it's easier for you to see.
I can see it
Okay.
fine here. The party is the people that are a part of the actual message.
Okay. And are these the labels, the names that are entered into Ashley Benefield's phone?
Correct.
Okay. And the next column,
The description, will, in this case, the first one is blank, but ultimately will have the body of a text message. Sometimes it'll be empty depending on the nature of it. But that's where the body of the text messages would be.
okay, so the next column,
The source is just the software's way of saying if it was a native message or if it was taken with a third-party application.
okay, and the next column,
The attachment is the actual file itself. It has a lot of metadata where that file actually exists and file paths and size. And if you look at the table, all this information comes from databases, and it explains where or what table the database that this message or this data lies.
okay. So let me move it back over. So after we get through this explanation, we'll move much faster, but the first message is what? If you could just explain to us what that is.
Item number 1 is listed as a message. It's an incoming message with an attachment, and it appears there's no body to it. In other words, there's no actually text string. It's just the actual attachment itself.
And who is it from and who is it to?
It's from Doug to, I'm just going to say the name that's on the actual.
That's fine.
It says Ashley Christina.
Okay. And is this the attachment?
Yes.
Okay, and if you could just read for the record what that says.
Says, am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bondservant of Christ.
Okay. And then the next message is what?
Number 2 appears to be an outgoing message. It's from Ashley Christina to Doug Benefield.
Okay, and how much later than the first message is that?
About 2 hours, it appears.
So we're starting to hear.
And
messages
so
sent
from
to
Ashley to
Doug
Doug,
by
and what is it?
Ashley.
The description says loved an image.
Okay, so she loved the image from before.
Correct. That's more of an action than actual writing something out.
Okay, she didn't type loved image.
No.
The phone is saying that she hit some button
Correct.
to love the image. All right. And then the next message is from right about the same time, and that says what?
Same time, that says good morning. There's another little icon after it, but it just didn't come out on here.
Okay. And then if you could just continue to read.
The next message, number
Right,
4.
the next
Okay.
message. If you can just say what time.
Okay.
To and from, and then what the message is.
So the next message sent around the same time, 10:36 a.m. It's from Doug to Ashley Christina. It says good morning with a few emojis. Then the next message after that, there's appears to be an attachment, and that's at 11:43 from Doug to Ashley Christina.
And what is the message right after that? Oh, I just went too far. Right after the attachment, I'm sorry.
Right after the attachment,
Yes.
it would be number 6. It's a message at 9:20, 11:43 from Doug to Ashley, and it says run baby run with a few emojis.
Okay. And so now I'll just play the attachment.
Gosh, the sounds of kids' voices always
Okay.
hook me up.
So Doug says run baby run to Ashley, and then what does she do?
That would be number 7. It's a instant message right after. It's at 12:16, and it just says laughed at a movie.
Okay. And if you can just keep reading.
Number 8 would be an outgoing message. It's from Ashley to Doug. It's on the same date at 12:16 p.m. It's just a few emojis. They appear to be laughing emojis.
And you don't have to mention the times right now until it switches a large
Okay.
time span. So go ahead.
The next would be an incoming message from Doug to Ashley, asking ready to rock and roll. The next is from Ashley to Doug, give me a few LOL, trying to round up the cats. It's like trying to teach a ballet to squirrels. The next is an incoming message from Doug to Ashley, says ha with exclamation points. The next is
And we've established that it's all either from Doug to Ashley or Ashley to Doug.
correct.
So if you can just say who's speaking and then the message from this point.
Number 12 from Doug, he says, that's funny. After that, it's from Doug, says he's liked, give me a few. It's basically liking a previous text message and it just repeats.
Okay.
The next is an outgoing from Ashley, says, OMG, I'm exhausted, LOL. The next is also from Ashley, you can come over now.
Now, I didn't ask you about the color coding on this, but what do the colors mean?
It was just to make it easier to read which one was outgoing, and on all the outgoings, which is Ashley's phone, are Ashley's phone, and the incoming is the other color.
And so the outgoings are what color?
The outgoings are the blue gray.
Okay.
Yeah.
Or the
I'm sorry, blue gray. The outgoing is the orange.
orange. Okay. So if Ashley's speaking, it's orange. If Doug's speaking, it's gray.
Correct.
So I believe we ended it. OMG, I'm exhausted. LOL. Go ahead.
I believe I had stated the outgoing message. You can come over now. Number 16 from Doug. Hot. Need to video the rodeo. Okay, headed that way. From Ashley, she responds, she liked what he had said earlier and just repeats. Incoming from Doug, I'm walking around to back. The response, I could let you in the front, or which, and then adds to that whichever. He responds.
So these are important messages, and I'm having trouble seeing the date because the camera is cropped off the date. But I'm pretty sure what they're showing here is that they exchanged messages right before he came over, where she's like, okay, you can come over now. So when she called the police, and I hope I'm not wrong about this, but what we were talking about in chat yesterday and the day before is, and I think it was Mauve who was saying, you know, they really need to establish that she lured him there, and it was no surprise to her that he was there. He was not some intruder that just showed up, and I think that's what they're establishing here.
Okay, front good. She responds with a thumbs up. He responds, me and XS boxes arrived.
And just as a side, as a totally separate thing, Johnny, my kids did that too. My kids used to wear fake glasses all the time. It's a thing. Kids have these weird things, and a lot of it is from social media trends that come about.
She responds, LOL. He responds with a message that includes an attachment without a body. Then there's a call log, which is number 26. It's an outgoing call log to Doug for, I believe, 11 seconds.
Okay. And then let me scroll down on here. After the phone call, what happens? Oh, let me back up just a second. What time was that phone call?
Same date, 9/27/24 in the evening.
And then at 8:58 in the evening, that next entry, what is it?
It is a message from Doug. It says, good night, sweetie, theta waves, with a couple emojis. I'll be done by 1 tomorrow and plan on joining the party. And then there's an outgoing, and then again, another action of just loving that previous text message. And then there was a response at 9:23 that says good night with a couple emojis. Huh, you sure you want to come hang out with the slum? ? And 9:23 he responds, yep, be smeshin' at the slummin'. 9:24 there was again an action of laughed at the previous message.
Okay, so that was at 9:24 PM, and it looks like the next entry is at 7:36 AM.
Correct.
And what is that?
That is believed to be an attachment without a body. It's a long string of characters, JPEG image.
And that came from Doug or to Doug?
That was from Doug.
And I'm going to display the attachment. You don't have to read all of this, but what is this?
Just another Bible verse.
So after the Bible verse, what is the next thing that happens?
She appears that she loves the image and then responds with good morning. He responds back with good morning with several emojis, and hours later responds with or says headed that way in about 30 minutes.
So that's approximately 3 hours later. He says headed that way in about 30 minutes.
Correct.
Okay, go ahead.
There's a response from Ashley that says, oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today, LOL. We'll have to round up the cats when we get home anyway. There's a response from Doug, oh, nice, a little breezy, which helps. Getting early start so can finish up early to come over and be with y'all and play W. Emerson, typically shorthand for with. Emerson, free y'all up some. Just ping when good to head over. And Ashley responds with a like of that previous message. And then responds with will do, and also adds in a new text message, want to grab a can opener at Publix on your way over, ? LOL. I of course packed the one we had. He responds.
So you notice here, he regularly asks before he comes over if he can come over.
Incoming message appears to be an attachment as well. That was it.
Go ahead. Some of these attachments don't open on this computer. Can you explain kind of why that is?
I think that one of the previous videos that you had, sometimes it's a codec issue. The files are actually not necessarily embedded in the actual spreadsheet itself, but I can take the same file and bring it over to another computer and it might open. It just depends. It depends on the computer how it's set up to open that particular file.
Okay. So after the attachment, I'm trying to slide this back over. Let's see. Let me try to open this. Okay, so this is one that will not open. So I slid it back over. If you could tell us again, starting at 46, I believe it is.
Well, after that attachment, it's 45.
Or 45, sorry.
And it's an incoming, says from Doug, in the crazy loop at Gay, G-A-Y-E. And it's probably a misspelling because he corrected himself and put gate in the next message. There is a call log that has 0 seconds to it at 3:17, and then an incoming message walking around back, and then
So the walking around back is approximately what time?
3 o'clock in the afternoon, or
And then-
3:21,
The next message is approximately what time?
9 o'clock at night.
And that message is?
Good night. And she responds at 9:22 with good night and looks like a sleeping emoji.
And the next communication?
The next would be an incoming message from Doug to Ashley. Um, appears to be an attachment, some type of JPEG image.
And you don't have to read this, but what is it?
It's another Bible verse. Believe we're on, after that attachment, we're on 52.
Yes.
It is an incoming message from Doug. Says good morning with some emojis. Hope you slept okay. She responded at 9:28. Loved the image, or loved an image, and also an additional good morning. Doug then emphasized the good morning, just another action that he took on a previous message. And the next communication was at 11 o'clock a.m. with a wave emoji, looks like. Then 11:22, he responds again with how's morning. She responds with also a wave emoji at 11:26, then says, good, the scramble to get all the loose ends tied up, LOL. He responds, no kidding, I'm done. Around 1, we'll head that way. Been going since like 3 a.m., LOL. She responds, OMG, 3, why is that? He responds, just to get work done so can pack. Love mornings all quiet. She responds, okay then. He responds, Spark is best friend, LOL. She laughed, another action for that message. And another response from Doug, finished up here, yay, headed that way.
And what time was that?
That was at 1 o'clock in the afternoon, 1:17.
And then after that?
At 1:19, she says, oh, take your time, no rush in, not in a rush today. And at 1:20, a response, LOL, with an emoji, think we all are getting pooped from the efforts. She responds with liked a previous message and it just repeats. There is also a laughed at LOL, again, laughing at a previous message. Then another message at 1:36 says, can you think of anything we need at Lowe's or anywhere? Then there's actual call log at 1:42 that lasts about 49 seconds. And that was from Doug to Ashley. And then at 3:30, there's a message from Doug, headed that way in a few minutes. I'd nothing need. And a message from Ashley, alrighty, we are just out for a walk, still can't think of anything needed at the moment. There's an action liked already, and the message repeats from a previous message. Doing front gate, I'm assuming circle, but CIRCL. And a call log from Doug to Ashley with 0 seconds. Incoming from Doug, I'm here. And it looks like another call log for about 20 seconds.
And that's
that's
about, I'm sorry to interrupt, that's about what time?
That was at 3:56 in the afternoon.
And the next message is at about what time?
9:26 p.m. It's a message from Ashley Christina to Doug. It says goodnight with an emoji. And then after that, Doug responds, good night, precious girls. And after that, Ashley, again, an action of loving that previous response. And the next several messages appear to be related to attachments.
Okay. So the next attachment I'll put up. Who were these attachments sent from?
These were from Doug to Ashley Christina.
And then in the middle of this, so it would be, I'm not getting the lines correct, but I think it's line 87 maybe, at 92935.
92935 is line 86,
Okay,
and that's another action of loving an image.
okay. And there's one more attachment, I believe.
So now I've counted, I think, at least 3 different instances where you can clearly see they have a relationship where he's like, they're very actively talking to each other. And she's not telling him to go away. And he respects the boundary of, I'm not coming over until you say it's okay to come over.
This action that we've referenced where she physically takes it's not word that she's typing, it's just physically within the operating system of iOS, it allows you to take an action on an image. In this case, she loved 1, 2, 3, 4, 5, 6.
Okay.
6 images.
Okay. Let me get it back centered again. So after she loved the images, there's an entry where she types a message. What is
Yes.
that?
That's at 9:31 at night. She responds, "All these are sweet, thank you." And he responds with an action that he loved the previous message, and then responds with "Y'all rock my world" with a heart emoji. And she responds again with an action of loving that previous message, and with it's a very small emoji, hard to tell what it is after the action.
And then what's the next entry?
The next is an instant, is a message with an attachment, and that's from Doug to Ashley at 6:47 in the morning.
I'm going to pull up the attachment. And again, what is that?
Appears to be another Bible verse.
And if you can continue.
So after, there's a message from Doug, says good morning with emojis. And then also an additional message at 9:28 that says, got an email from Stephanie after she talked to Faith. Since order to mediate will meet for 1 hour tomorrow to stop court next week. You dismissed injunction. We sign joint stipulation to dismiss dissolutions and hold until the Moreland signs. Order for report. Looks like praying hands emoji and a heart. And then there's an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots and red-blue inversion. After that, there's an action by Ashley Christina that said, loved an image. And it continues with a good morning. And there's an emphasis by Doug of good morning. Ashley Christina responds, oh, okay, I'll reach out to Faith to follow up on all the above with a thumbs up. Doug takes an action about and liking that previous image, and then says, and we're done. Again, praying hands emoji, and also responds, and all in first 10 days of Jewish New Year, LOL. It continues with an action of laughed at the previous message. And then at 9:57, Doug responds, you gotta laugh, September 18th was first date of Jewish New Year, 3 years to date of your Odyssey starting day of ballet launch, Rosh Hashanah, the first of the Jewish days of awe. We can call our Odyssey the days of all, LOL. At 10:13, there's an incoming message, says from Doug, so perfect outside, looks like a sun emoji. Ashley responds with an action for those previous messages, which just repeats, and then writes, oh yay, we should do Selby today. He responds, oh yes, with multiple M's and yum. She responds with a few emojis. He emphasized the emojis, and then adds, Stephanie just sent Faith joint dismissal of everything except injunction. which Faith has to do, just one pager, and also responds, what time thinking Selby? Actually, Christina responds with the action of liking it, and then says, maybe 1:30-ish, I'll text you when we're headed that way with a thumbs up. He responds, or Doug responds, okay, I can come pick you up too. Then adds more time with my baby. Then adds mediation tomorrow by Zoom 10:30 and be quick. Actually responds with the action of liking that. Then added, sorry, just looking at my phone. You don't need to drive all the app back to LWR to get us if you are already downtown. But if you want to, that's fine. Just let me know either way. Doug responds, I'm at apartment. Adds, so pretty, enjoying pool area, finally to work, LOL. The next message is an attachment with nobody.
From Doug,
That is from Doug to Ashley Christina.
and I'll pull up the attachment. I don't know why I just closed that. Let me open it again. And what number were we on?
132, that was the attachment.
Thank you. Okay. So after the attachment, what's the next communication?
It's a message from Doug to Ashley Christina. I'll just head your way at 1:30. Ashley Christina responds, hot, nice, okay, just getting our things together now. Maybe head over in like 10 minutes. 10 MIN. Doug responds, okay. And then after that appears to be an email from Doug to Ashley.
Okay. And after that?
After that is incoming message from Doug. Do you want to get together tonight or in the morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out. She responds, ha, okay, thumbs up. He responds, thumbs up. Prefer tonight, maybe run over Pandera or in AM, question mark. And she responds, sure, can do Panera tonight.
Okay, so I want to back up a little bit. We were talking about the entry that was the email before that. Does it have the content of the email in this spreadsheet?
Appears there's quite a bit of metadata involved, but the actual content from what I'm looking at is not actually in there.
Okay, does it say?
I've been kind of watching Ashley during this whole thing, and she looks a little bit deer in headlights, almost like she's afraid, like she can't remember exactly what was said in these messages, and she's afraid of what she's going to hear and what's going to come out and how it's going to be portrayed. And either that or she is kind of hearing how this is playing out in court and how it would come across to the jurors and going, oh shit, this does not look good. I'm just basically sitting here, I've tried to convince all these people that I'm an abused woman, and here I am, literally having no problems with him, at least via these messages. And I've given him permission, and he's asked permission many times to come over. So, unless something very volatile happens, in the course of these text messages, to justify what she did, we're just not seeing it yet, right?
Any names associated with the metadata?
There's an email address of Stephanie Murphy. It's at murphylawsarasota.com. There's an email address related to Doug Benefield. And there's believe those are the two names that I see that are associated with.
Okay. So we left off at sure can do Panera tonight.
Yes. And adds 8 ? She responds with a thumbs up. And that was at 7:27 p.m. And she responds with at 9:55 p.m. with a good night and a sleeping emoji. And he responds also with a good night with another emoji. He adds sweet dreams and then also sends an attachment. Correction, the sweet dreams was the last one at 9:56 p.m. The attachment I just referenced was actually 7 o'clock in the morning the next day.
Okay, so the next day I'm clicking on that attachment. And what is that?
Looks up here, a Bible verse.
And what are the messages after that?
All right, so attachment. After that, there's a good morning with a few emojis. If you want, you can come over here for Zoom. And adds, we can grab bagel and CHI. It's 10 a.m. BT, by the way, BTW is for short. And then there's a phone call at 9 o'clock, 9:07 with no seconds. There's a 151. It says there's an incoming message with no body. And then after that, there's an incoming message with an attachment. It appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment and see if it will come up. It's one of those that will not come up. So go ahead.
the next after that appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues where Ashley Christina loved an image, then liked the message. It's 10 a.m. by the way, and then added, "Ha, oh man, okay, thanks for the heads up." He responded by liking that, and then added, "Set up here if easier for you." And she responded, "That's okay. I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone." He responds, "LOL, you can." She liked LOL, you can, and then added quick and easy LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added, "So nice to experience quick and easy. Finally, LOL." Then adds, "Smeshing good." Then adds, "PS, you looked great for just rolling out a couch. LOL," and added an emoji. He added, "I'm working on brief, head over soon as get to stopping point like 1. She responds with the action of loving the previous message, or one of the previous messages. "So nice to experience quick and easy." Laughed at also the PS, "Looking great" comment. And then added, "Ha, thanks. Figured I should put a clean shirt on even if I had PJs on the bottom half. LOL." She adds, "And okay, just let me know as you're finishing up." He adds, "Just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall price about the same. U-Haul, more flexibility, like taking things straight to storage." She responds, "Okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind." Mom and cats will go in the Jeep and I'll drive with Emerson in my car. She added LOL, the Beverly Hill. He added LOL, the Beverly Hillbillies, coming from dem slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added headed over shortly, brain approaching short circuit. She added, ha, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up. He added, he liked the previous message. And then there's a outgoing phone call to Doug for 38 seconds. Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night with an emoji.
Okay. So the liked headed that way was at what time?
That was at 2:00 in the afternoon.
And then the good night was at what time?
It's 8:27
Okay.
at night. Saw two of them, apologize.
And then after the good night?
After good night, there's an outgoing indeed, LOL, good night, from Ashley. And then after that, there's an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
And the next entry?
Appears to be another attachment roughly 15 minutes later.
Okay. And if you could read what this says?
Live a life filled with love. Another Bible verse, Ephesians 5:2. At 9:26, there's a message from Doug that says, good morning. Minute later, there's an action of loving an image. Second, loving a minute image. And he responds with Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
Chai. At 9:27, there's a response from Christina that says, good morning. There's a repeated response, previous message. Dr. Q is at 10:30. Do you want a chai? And then bagel, he added to it. She responds, ha, that's okay. Thank you. If I do that this early in the day, I'll be done for the day, LOL, but thank you. He added, he liked that message. And the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open. And then the next entry.
It's at 10:35 a.m. From Doug, are you able to make Dr. Q okay? She responds, yes, LOL, be in a minute. He responds, no rush. He's still not out, LOL. She responds, I know, LOL, waiting for mom to come out so we can swap. There's a message without just a rectangular square there. And then after that, there's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now the LOL was at 10:42 a.m. And then what's the next entry?
correct. 10:42 a.m. was the LOL. And then the next is at 5:39 p.m., which is a phone call from Doug, and with 0 seconds. Then adds after the phone call, I be here. And then another phone call for 15 seconds at 5:40 p.m. Then,
Your Honor, not to attack Sergeant Keyless because he's been reading for a while, but it's a little tough to follow. I wonder if he could give us the number of the message, so it would be much easier to follow.
That's fair.
And I don't know why, but I think your numbers may be off. You,
Off different from this.
they might be. Can you look?
IB here is, well, we're not using the numbers that are built into Excel. I want to say
Okay.
the
That's what
numbers
it
are
is.
an actual column. So technically IB
Hang on, I'll move
here,
this over. That's what you're looking at.
correct. IB
Okay.
here would be 212.
If he gives you that number,
We're-
are you okay with that?
Can you show him?
Like on yours, 214. Just 214. These numbers here match what he's saying. There's numbers on the Excel spreadsheet showing.
At 43 a.m.
And that is on the next day, correct?
Correct.
9/26.
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
And then you can continue from
All
there.
right. So moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log with from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message and then it repeats. 224, want to come pick me up and we can go get the truck.
And that's from Ashley.
And that's
correct?
from Ashley.
Okay.
And Doug responds, sure, with 225, sure, headed that way. So at 226, IB here. And that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening. And it's from Doug, and it's a good night, sweet dreams. Then at 228, 9:23, Ashley responds with the action of loving the previous message and also responds with a good night. 2:30, there's another attachment at 6:42 from Doug to Ashley.
I'll pull up the attachment. What is that?
It's the Bible verse. After the attachment at 2:31, Doug sends good morning. 2:32, she responds, loved an image. And 2:33 with a good morning. 2:34, he responds what looks like a strong fist up emoji. And 2:35, there's also an incoming from Doug with just a little rectangle. 2:36, she responds with LOL. 2:37, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 2:38, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 2:39, how's it going over there? Making progress? He responds at 2:40, number 240 at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, AKA bed. Pretty much emptied. Taking solely to get his shots, then to doggy spa to get groomed and stay until ready to go. 2:41, he adds, I'll come there after drop him off at 3. .242, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds, 244 adds, great, could you run by Lowe's before you come over, grab a few large and mediums. 2:45, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure, I need a few, which just repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bits here. 2:48 from Doug, he likes the previous message and adds, and 2:49, okay, let me know anything else if think of. 2:50, she responds, tape. 2:51, and also adds LOL. 2:52, he responds, ha, K. 2:53, just finished vet, headed to spa, LOL. 2:54, she laughed at that previous message. 2:55, he says, headed there. 2:56, she responds, okay. The next line, 2:57, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time
This
is
is
that
the day
during
of
the
the
day?
That's about 3:54 in the afternoon,
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two.
Correct.
Okay, so after, okay, 1 minute, what is said?
Then 2:59, about to head back from Doug. And then the message after that appears to be an attachment at 5:11 in the afternoon.
And I'm clicking on the attachment for the record.
Appears to be,
Go ahead, I'm sorry.
it appears to be maybe the U-Haul truck that they're loading up.
And that was sent from Doug?
That was 5:11. Yeah, that was incoming. Yes, from Doug to Ashley.
Okay, and then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
There you go.
Thank you.
We're on the way.
Judge, can we approach just a moment
Yes.
before?
Knew he was coming. She was totally okay with it. She completely participated in the idea of moving away with him.
Amongst yourself. It should take about 10 minutes, it's my best guess. So please don't begin deliberations amongst yourself. You can't communicate outside, send and receive texts, emails, telephone amongst yourself. Members of the jury, there's one legal issue that I need to resolve before we finish up. Get you back. Use you for right now, just to be cautious. Please understand the rules of here. All right, so just step outside. Sure. Get you back in as soon as we can. No, I think it's fine because I think they're still going to leave them down. I can see all right.
So I guess they do this impromptu hearing now.
Okay, the detective is out of the room. We can have argument on this video.
Thank you, Judge. And thank you for rehearing the issue. I had a chance to research and we obviously weren't.
If you've got case law,
Well,
contrary to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thank you, sir. I actually just sent one to the printer because I didn't know if you'd rather have it, but it's called Lumarque. I don't know, Lumarque. It's 44 Southern 3rd, 171.
Say that again.
Sure, 44 Southern 3rd, 171. There's a yellow flag, but it's for a different reason. This case was,
Judge, are you looking it up electronically or would you like a hard copy?
No, I
okay.
I'll take a copy if you have one.
Give me 1 second, Coach. Sorry.
Oh, that's all right.
They were only
Is that the only one you've got?
they
No,
were
you can
only
have it.
taking one at a time.
For you.
Judge, they will vote my copy.
I should come any second. Where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law. That's my understanding and my feeling, but that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third DCA here said the court erred. The images and text messages were found on the defendant's cellular phone.
Can you slow down just a little bit for the court reporter?
I apologize. The images and text messages were found on the defendant's cellular.
Okay, so they're going to argue about whether to bring in video evidence. I'm not super interested in their legal arguments about whether to bring in the video evidence.
Phone seized pursuant to a search of the defendant's home.
It was sent 9/20 of 2020 at 6:40 PM.
What number are you referring to?
Oh, 25.
Just gonna put him back on the stand. The jury won't know any different. All right, so if we can bring,
Can you take a quick restroom break?
all right, 5 minutes?
Just 5
Sure.
minutes.
Okay,
Thank you, Judge.
Yeah, sorry.
bring him in.
I'm gonna play that attachment at this time.
So the judge obviously ruled for the video.
How do you know what it's doing? I think it's giving you clues that I gotta guess.
Is it like with words? I'd say not safe.
Get real?
Second word.
Real?
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. I live in a
Slum.
people said really like great.
Oh no, it's running out of time.
I live in
House.
a
Real house. Wife.
So put together.
Oh, housewives of. Oh, real house. Oh.
Okay,
Well, that's your
thank you. I have no further questions.
Cross. And Mr. Taylor, do you want the screen or do you want the lights back up?
Establish the contours of your testimony. From the technical services unit, you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the messages. You just are able to read what's printed.
I can read what's printed from the extraction, yes.
Right. But for example, there were quite a few Bible verses. You wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I could tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass to you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
Solo.
I would object to. be
Solo,
honest,
are
though.
you listening? Did the law firm
Okay,
get back
I
to
don't know.
you?
Come here.
Tell you what Neil Taylor has worked on? Zooming forward.
What I've marked now as Defendant's Exhibit 3. Those would they not, text messages that you also extracted?
I believe these were the text messages that you may highlighted during a deposition, and
Yeah.
we
and that-
confirmed that these came from, I believe, Doug's phone.
Correct.
Yes.
And that we requested.
I apologize, Judge. I do think we need to approach it now.
Sidebar, 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 sidebar. Sidebar, sidebar. Lolly, lolly, law. That was a long sidebar.
We're going to let you go also for lunch. Just remember the admonitions from earlier. Don't discuss the case.
And
with
then they
anyone.
took lunch, and they're still at lunch. Let me just see what time he tells them to come back.
All right, members of the jury, this is going to take a little bit longer. So what I'm going to do at this point is it's about 11:30. I'm going to let you go to an early lunch. So if you could be back downstairs in the jury assembly room at 12:45, that gives you a little bit extra time. That'll give us time to take care of what we need to take care of, and we'll get you back up here as soon as we can right after your lunch break. Please remember, don't discuss the case amongst yourselves. Don't discuss the case with anybody else, and don't do any research on the people, places, things, or legal topics you've heard anything about. All right, thank you.
Looking at the body language. Looking very nervous.
All right, you go ahead and bring up the lights. Okay, Detective Keyless, we're going to let you go also for lunch. Just remember the admonitions from earlier. Don't discuss the case with anyone. Don't let anyone discuss the case with you. Don't talk with any other witnesses. You can't talk with the attorneys about your testimony. Don't do any research or watch anything online. Understood. If you could be back here at 12:45. Sure. All right. Thank you, sir.
All right. So I'm going to stay live. I have a couple videos I want to show you. Because they're going to be back in like 35 minutes or something like that. So, where did I put that? I guess I must have just saved the links. Last night, yesterday, the Court TV aired an interview with the creepy cousin. who Attorney Taylor called creepy. And he was interviewed on Court TV that day. And I thought his interview was pretty interesting. So check this out.
In particular, because I had several weekends and several events with Doug and Ashley specifically, and that I ended up maintaining that open relationship, open communication with her long after they separated, giving her a chance to voice her concerns and allegations all the way up until my deposition in 2018. I believe we had a good day today in the prosecution side of the presentation. This is still the state presenting their information all day today and into tomorrow. It was very, very clear where Mr. Taylor was trying to go in his part of the case. But I don't think that the case is going quite the way he wants to. We have the single events that Doug admitted to a long time ago, but we don't have any events ever accused of him or found true of him once Ashley moved to Florida. So there's a big difference between what happened in the home in South Carolina and then all the 2-3 years that they were in Florida off and on together.
Now, there was a moment today, and as I'm watching this, the jury's out, you're out of the courthouse as well, and her attorney starts talking about you because there's some dispute about some testimony that they're trying to get you to talk about. So I don't know if you've seen or heard this, but I want to play it for you to get your reaction. Here again is Ashley Benefield's attorney talking about you.
As succinctly as I can, Your Honor, he's a creep. He acknowledged being a creep, and the jury will conclude he's a creep. It goes directly to his character and his bias. And that's why, after he said, yes, it was accurate, I recall it, he cannot bring himself to say it. And the reason he can't bring himself to say it is because he knows that all these women on the jury are going to know exactly what he was referring to.
Okay, so Tommy, I heard that, and folks watching heard that. I wanted to give you some time to respond because there's the rules of the court. You can't say everything you want to say on the witness stand. So give us your side, because this is all referencing text messages between you and Ashley, and in one of them, it's alleged that you said that, oh, Ashley, you married the wrong Benefield.
And that's not what the bubble says. It specifically said wrong Benefield. What I tried to do was give it the context appropriate to what Ashley has said in the text message prior to that. And of course, he's painting it the way he wants to. I've never in my life ever been accused of anything that he accused me of today. I was answering that what she was looking for in conduct, that there were different Benefields, and she was talking about the wrong Benefield, the wrong behavior. And
for what it's worth, that's the way I took the message. And that's that whole line of inquiry and the way the lawyer treated it is what completely turned me off to the defense, because they imbued so much more negative pejorative meaning into a text that just said wrong Benefield. They made it sound like he said you married the wrong Benefield. He didn't even say anything like that. And there's not even any context to suggest that he did that he was coming on to her. So that's when you see that when you see such weak tactics like that coming from the defense, you also are getting a signal that they have a very, very weak case and they're grasping at straws.
I've never been accused of being a creep. Everyone in my company, ever in my business, everywhere I've ever been, no one's ever accused me the way he did today. Disgusting is my point of view. I was out of the room for it. My family and I talked about it this afternoon and this evening. But the accusation that they're making about that statement is completely out of context. And I certainly was going to try to give the question and answer I gave, as opposed to just that single bubble by itself, because that was not part of the way that treatment and that testimony should go.
And I got the feeling that there was a little more to it, and it's about context, but obviously we know what he's attempting to do and what's happening. So this trial's moving very quickly. Are you guys and your family and everyone else that's down there, you guys staying till the end here?
We'll be all here all the way through. Benny, there's one very, very interesting thing that happened today that was outside of anything we had known previously. And certainly the testimony of the deputies and the folks who came on the scene at the Ashley and Alicia's home where Doug was killed. The fact that the gun turned out to be, we'll call it jammed for the sake of that. But we always wondered why Ashley did not shoot all the bullets out of the gun. We found out today that after 4 shots into the 5th shot, the gun jammed. That was new information today we had not ever had before. Very, very interesting that when the police picked up the gun from the neighbor next door and from Ashley, it was still jammed.
And before we go tonight,
I thought that was interesting that they didn't know that the gun had jammed. And that's so interesting because the gun did have 6, shots in it. And what he's basically saying is that she would have shot all 6 bullets if the gun hadn't jammed. And I have no reason to believe that he's not right about that. But going back to our old-timey crimey shows conversation, obviously people from the time of Kingdom Come have had a huge fascination with crime and solving mysteries and stuff. It's in our lore, obviously it's like this grand human condition to need to understand mysteries and figure things out,
are there, for Eva, I know that she can't talk to you because she's still under subpoena, but your thoughts about her tonight being in the courtroom, being there with Ashley. She's now allowed to at least watch the rest of the trial from the gallery, but she can't talk about it, obviously. But your thoughts about her tonight?
Eva has been very courageous throughout this. She's very outspoken with her influencing on TikTok, and in particular about her recovering from the trauma of losing her father after losing her mother previously. I think she handled it very, very well today. And we were very happy that the state prosecutor invoked Marcy's law, which is the law where the next of kin can be in the room. So while she is a witness and she has not been released from that subpoena, she's in the courtroom getting to hear the testimony as Doug's next of kin. We were very, very thankful for that. She's been very courageous, and she's just telling the truth about what she saw.
All right, Tommy Benefield, Doug's cousin, family.
So that was Doug's cousin giving that interview after he testified. I thought that was interesting. And it's really nice to see what he was basically saying is that the whole family came in to support, Doug, the deceased, and they're going to stay there. So now I'm going to show you Eva's TikTok. And the one I'm going to show you first is the most relevant, but I'm going to also show you a few others as well. Hello, why aren't you playing? It's not playing. I wonder if she took that one down or something because she got admonished. That's interesting. It keeps stopping. I need to do a new link or something. Hold on a moment. Okay. Huh. That is really weird. Well, let's watch it this way.
Clear my head before I have to go in a week and a half and testify in my father's murder trial. I was shown this article today about a woman who had a rally to support her because she shot and killed her husband. This is the article.
So what I find interesting about this, so Ashley, I'm sorry, not Ashley, Eva here is talking about the rally that in front of the courthouse for her stepmother who murdered her father, right? And it's really cool and interesting to see an actual family, true crime family members take on what it's like to have people coming out and giving support to a murderer, to somebody, to an actual murderer, you know? And yes, of course, innocent until proven guilty, but there's no dispute that she pulled out a gun and shot him. It's just the absolute lack of empathy and lack of compassion for the victims when people come out and protest in such a fashion. And just listen more to what Eva says, because I think she makes very good points.
It's basically, y'all can probably find it. Well, there's a lot of things that I could say. I don't feel like saying them, honestly. I want to save my words, but there's two main points that I want to get at, which one, they show my father's other daughter that he had with this woman who shot and killed him, Emerson, and she is 6. This happened almost 4 years ago, so she was roughly 2 years old when her mother shot and killed my dad, our dad. Emerson had no idea she doesn't know what happened, and she has no idea what's going on now either. So I think that we should probably stop shoving cameras in 6-year-olds' faces when they have no idea what's going on. This is all just probably to taint the jury pool. The other point that I would like to make is there are signs saying that she is being punished for protecting herself, because this entire time she's claimed self-defense, because my dad was attacking her. Now, I've looked at the evidence. I've seen the evidence pictures. I've heard everything I need to know. I've talked to all the detectives I need to talk to understand that my dad was not attacking her at the time that she shot him. She shot him from behind. One of the bullets went in through his rib cage. He was turned to the side. He was picking up another box. He was not attacking her. There wasn't a piece of evidence, or there wasn't any DNA of hers on my dad, and there was no DNA on my dad of hers. And then also, there was no bullet, there was no gunpowder residue on my father, meaning that she shot him from at least 6 feet away. As a woman.
So those are things I don't think we've heard in the trial, is that there's no and if we've heard this, it wasn't made very clear, okay? That there was none of his DNA on her and none of her DNA on him, and no blood splatter either way, onto onto her from him. So she had to have been pretty far away. So there just is no, and then where the bullet went into him and how it killed him was from his side, and he was reaching up. So, and we can see from the text messages that he wasn't some, unexpected intruder. She fully expected him to be there. So this, really is a circumstantial case, but the closer they get to showing that she had these motives, or it's the harder and harder it is to explain why she would do all these things, the more and more likely it is that they're going to need to put her on the stand to explain. Explain, Lucy. You have some splaining to do.
woman who is adamant about women's rights, Ashley's making this a whole lot fucking harder for women who are actually in abusive relationships to get the help that they need. She cried wolf too many times, and
Okay, I
then
must
she
have missed
killed
it.
my dad. She went to the court time and time again, and she lied to the point where there's an actual audio clip from one of the custody hearings that my dad and Ashley both attended, where the judge said that there is not one scintilla of evidence that proves Doug Benefield is guilty of any of Ashley's allegations against him. That's all I'm gonna say on that right now. I don't have a lot of energy. Like this all is it's becoming a lot. It's very surreal. But yeah, that's just kind of where I wanted to touch on, because that video made me really fucking angry, and the fact that I really do think that it's all just to taint the jury pool and whatever, make her look like she's a victim in all of this, when in reality my dad was the victim of emotional abuse, really.
And I agree. It really, really, really sucks when people come out and falsely cry victim, and they do it in such a big way, and then they're found out to be frauds, because then it discredits all the real victims. The one good thing I can say about it is that because there is so much of that going on, because there's more of that kind of I'll call it Darvo, where the abuser cries victim, right? There's so much of that going on that it's now becoming easier for people to differentiate the aggressor from the victim. It is becoming easier, but it's a long process, and some people are further along in their journeys than others in being able to understand how to tell the difference between when someone is being the aggressor and the manipulator and the controller, and when someone is responding and just coping with that distress. So let me I don't want to get hit with copyright, but I want to see if she's said anything today.
Remember how I told y'all that I was nervous about my crush watching me on live TV? Well, I literally told y'all, no, but in all seriousness, I cannot talk a lot about the trial right now. I will when I am allowed to. But a lot of people have been asking me about my jewelry, specifically this necklace. I think.
See, so in this TikTok, she's like, "Hey, look, everyone, I'm here." She's just making light comments about being, testifying in trial, and saying specifically, I can't say anything, but people have been asking me about my jewelry, so here's my jewelry.
I think I wear it a lot because it's my favorite necklace of all time. But it's D Ruel on. I'll tag her in the caption on Instagram, TikTok. She's a jewelry. Oh my gosh, brain is actually fried from today and yesterday and the day before. I'm exhausted. But she's a jeweler based out of Charleston. All of her jewelry is amazing and beautiful and gorgeous, and I love it. And this is one of a kind, custom made. So she cannot make another one. She made the choker and all of the charms except for this one. This one is from a different jeweler in Charleston. But yeah, if you go on her website and you go on her Instagram and her TikTok, you can see all the other jewelry she makes. She made this pearl chain earring for me, and I have a few other pieces of jewelry from her. I'm constantly getting jewelry from her because my art studio is in the back of her shop in Charleston. So if you're in Charleston, go check her out. But yeah, and then my other jewelry, this is my Oura ring, some bangles, and some permanent bracelets, and then I have this. It's like a Cuban link, but it's a hand holding that, and then these two rings. This whole hand is from Goldbug in Charleston as well. But yeah, I can't really talk about the trial, even though I am dying to talk about it with y'all. Every time I leave the courtroom, I turn my phone on and I scroll on TikTok and I see everybody's comments, and it just makes me so happy. But Yeah, now it's time to go figure out me and Margaret what we're going to wear into the courtroom, because that has been the most exciting part of our morning.
See, so the reason I played that whole thing is I agree. She is a sweetheart. You know, she just reminds me of my kids. You know, she's the age of my children, and one of my boys actually had a really, really popular TikTok at one time, and it was surreal to watch people interact with him in that way. But he doesn't do it anymore. But um, it's I wanted to watch through that whole thing because, you know, the thing she says at the end there is, you know, okay, now we're going to have to figure out what we're going to wear to court today. And that's obviously because she knows, and her friend know, that they're getting national TV attention because they're going to court. And I've recently watched a few different clips where people are like, he just lost interest, Johnny. He lost interest, and also he stopped using TikTok in that way at around the same time that I was involved in my very heavily involved in the social dilemma and the nonprofit, and he was, you know, getting enlightened to the information about social media, and he wasn't dependent on it at all. So he just kind of lost interest. But he at his peak, he had something like 150 to 200,000 subscribers, which is pretty good. This was like 4 years ago. So anyway, I do too, Patricia. I feel really upset for her too, because like she is an orphan. Like somebody said earlier, she's an orphan. Her mother dies. And if I remember correctly, not too long after her mother dies, he meets this woman, and 13 days later gets married to her, and then she's pregnant, and then it becomes this incredibly toxic, volatile relationship. Yeah, I know, Johnny. So let's watch a couple other videos, and then I want to have a little bit of a conversation about TikTok with y'all.
Every single morning this week. And action. Day 3. Feeling good. Got our coffee. Fit check. Yeah. Fit check. Margaret, fit check. Fit check. Catch me. Catch me. Yeah. Yeah.
It's so funny.
We're walking to the courthouse, and I don't know what's gonna happen, but here we are. Remember how I told y'all that I was nervous? I just testified, and y'all don't know what it's like to have to testify in your dad's murder trial and know that your crush is watching you back home on TV. That's nerve-wracking.
So see what I mean? How they're correct people, anybody who's going to go anywhere near a court and testify in a trial knows now that they're going to be part of like this social media and sensation. Absolutely, Johnny. Absolutely. It was 9 months after her mom died. 9 months. Jesus Christ. Well, I guess, you know, on the bright side, not that there is a bright side, it's more of a dark bright side. It wasn't like, you know, the Vallow situation where they were married 12 days after Tammy died or something like that, 17 days, something like that. Anyway, that's not a very good place to stop the TikTok. So I'm going to go like this. So there's a couple other things I wanted to show you while we're waiting. Okay. So what I'm about to show you has absolutely nothing to do with this case. But I watched it yesterday and I am absolutely horrified by this story. It's been a long time since I've been this horrified by a story. Okay? And I may not even it's hard to even think about whether to play this story. These two preschool daycare, no, it's not preschool, daycare workers violently abused babies in each other's presence at a daycare, and it's on video. They don't show the video in this news clip. Long Crime doesn't show it. But they describe what is written in the arrest affidavit for these two young ladies, very young, like in their early 20s, who, I mean, let me just play it for you. And I just have to warn you, it's horrifying story. Absolutely horrifying.
Minnesota are accused of unthinkable abuse against the children, both aggressively abusing children. And we haven't seen the video of this. I don't. Weimerslage of a child and 1 count each of third-degree assault of a victim under age 4. On July 16th, it's been reported that a parent called 911 to report potential child abuse at a daycare center in Blaine, Minnesota. According to this statement of probable cause, the 5-month-old's parents, remember that age, noticed bruising on her thighs, groin, buttocks, and legs. They contacted the daycare center to inquire about the bruising and were told it might be from the chair or swing in the infant room. Officers found out that the 2 employees for Infant One's room, that's how this infant's being identified, Infant One, were 24-year-old Chloe K. Johnson and 22-year-old Elizabeth Weimerslage. When police questioned Johnson, she reportedly said she saw some redness on Infant One's pelvic area in the afternoon on the 15th, and then saw it had turned to bruising on the 16th, but she allegedly said the bruising could come from infant chairs. Then, when police questioned Weimerslage, she said she didn't see any redness or bruising, but if there was, it was caused by the swing or chair. You know what the issue with that is? Police say there is surveillance video that shows what actually happened inside of that infant room. Now, I have to warn you, we obviously cover really horrifying crimes on Sidebar. There's no secret about that. This, though, is incredibly difficult to hear. I'm giving you that warning right now. With that in mind, and I apologize for this, but it's important to understand the allegations. Here we go. The probable cause statement reads, around 9:07 a.m., Defendant Johnson is sitting with Infant One on a floor mat and starts moving Infant One around aggressively. Over the next several minutes, Defendant Johnson grabs Infant One by her upper thighs, hip, and groin area and violently flips Infant One back and forth from her stomach to her back, not allowing Infant One to remain on one side for longer than a few seconds. Infant One's arms are flailing outward, and her body is consistently rigid as her face contacts the floor mat repeatedly as she is being flipped and her head is unsupported.
Can you imagine bringing your infant, your helpless infant, to a daycare center and then finding out, seeing bruises on your infant, calling 911, it being investigated and finding out that it's all on video and they were handling your child in this way? What the hell are daycare centers, or at least this daycare center, doing to vet their daycare workers? This is absolutely insane. It's incredible. And how much of a monster do you have to be to want to, basically take your anger and channel it into a helpless, innocent little baby? I don't get it, y'all. Oh, this story just, I just wanted,
There's no audio, but infant one appears to be screaming with her mouth open as this is happening. Absolutely horrific. And this statement explains that Weimerslage is there as this is going on and is seemingly watching this. But let's continue. In the video, defendant Johnson is also seen picking up another infant, infant 2, roughly, and holding a cloth over the infant's mouth and nose for several seconds while infant 2 is crying. Defendant Johnson is gripping infant 2 firmly by the neck before she violently pulls them up by the arm and shoves a bottle repeatedly in and out of infant 2's mouth too rapidly for infant 2 to be drinking from it. Later in the video, defendant
so eventually they describe similar instances with 3 different babies, 3 different infants. And the only bright side that I can see in this situation is it doesn't appear that it was sexual in nature. It doesn't look like these girls were little perverts or anything. They were just violent and sadistic and taking their, and not treating these little babies like children. I'm like human beings. Almost like they're like little dollies that they can treat however they want. I mean, I wonder how they've treated animals in the past. So anyway, I keep being absolutely shocked and surprised that there is so much that children are not as protected as they should be in our world. They are so helpless, and they end up getting the worst, the shady end of the stick because they're fucking helpless. And it seems like, I'm sure there's no question in my mind that social media had a part to play in, dulling the empathy of people, making it so people don't see other human beings as human beings, but just as things, and that is a teacup. I agree. That is another thing that, is good, is that there's a lot more camera action around. We're definitely a very surveilled society, but that also means that we end up catching criminals in the act a lot more often. I know, right, Patricia? What is it? How are they even getting jobs without some sort of oh God, this just it just really hurts. It just really hurts. So anyway, I wanted to just show you a part of that. They should be coming back. They should be coming back any moment. While we're waiting for them, I'm still a little bit in a little bit of a dilemma about what to do with content, you guys. Okay. I'm not gonna lie to you. Would I prefer not to be shadow banned? Hell yeah. Yes, absolutely. Do I know for sure that I am? No, I'm not, because no one ever knows for sure that they're shadow banned. No one will ever know that. But it's just a reality that I can't shake. Like it just is the most likely explanation for my numbers on my channel, unless you all want to tell me, no, Lynn, feel free to tell me, no, Lynn, your content just sucks. I don't think that's the case. Since I figured out that I got shadow banned, I certainly haven't put as much time and energy into my content. But because I'm still trying to figure things out. But my modus operandi is to get a message out. So there are many, many ways to get a message out, right? You can use social media. The best way for me to get the message that I want to get out is on YouTube, not via the other social media entities. And I want to participate in as little social media as possible. I literally am living a social dilemma because the one social media platform that I've chosen to use to try to get information out there is not going to want to hear the information I have to get out there. Right. And the message I have is always going to be silenced to a certain degree by the platform because it's against the platform. So Patricia, what I can do is start an entirely new channel. But here's the dilemma that isn't linked to the same email that my two channels are on now. But the dilemma with that is that here's my whole reason for even using YouTube and being on social media is to talk about YouTube and social media and how it's hurting us. So it's the only reason I would start a whole new channel is if I wasn't going to talk to a channel that isn't at risk of being shadow banned, is if I started a whole new channel that didn't talk about YouTube and social media. And I just don't see myself doing that, So I'm thinking about other platforms. As much as I don't want to do that, as much as I don't want to participate on other social media, I also want my voice to be heard as loudly as possible. Yeah, I'll pose as a Mormon family first. So I've been looking into other platforms to go live on. I've been thinking about TikTok. I'm not a TikTok fan, but I know how big it is. And I'm also, for me, it's just choosing like the evil, which evil am I going to go with? I mean, seriously, that's what it is.
All right, good afternoon, everyone. We're back on the record. State versus Ashley Benefield. We finished the lunch break, and before we bring Deputy Keyless or Detective Keyless back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Keyless on Defendant's Exhibit 3, which I will describe as, and it's been told to me that these are from Ashley Benefield's phone. And the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29th, 2016, and a last activity of April 19th, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29th, 2016 through December 3rd, 2016, And the page numbers are not sequential. That is, it's page numbers 1, 786, 222. I'm sorry, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly, State, I'm sure you have these as well, and may.
Well, I guess one of the issues, Judge, is that we aren't being showed anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB texts, but they're not all the same. There's some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over. May I approach? You don't want to. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million
IA report, internal affairs report from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier.
Trial by ambush.
But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense. And the original witness lists were filed in the late June.
That probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the, the defense has 15 days. So,
I can enlighten Your Honor.
All right, please.
They attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump, DUMP. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, searching. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed. But at the deposition, I clearly presented these to Sergeant Keelis, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
All right, final thoughts. I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think Your Honor is well familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little,
I'm sorry,
please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It is disingenuous for this defense team to say they are using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to this point where there are things being offered for evidence that have never been provided to the state that I can't even find at the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem we're having. And the obligations are different, as Your Honor knows, and I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substantive statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided. I haven't heard specifically. It may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keelis's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached to his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone number. We provided it to them. They listed it and said it's in our possession. So they did not provide us a phone
Okay, so she already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing, and that also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent, I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so
We could just request that be done before we're in the middle of examining it.
and copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about. That being Defense Exhibit 3. And we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes, court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes. Okay, so we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Ms. Benefield that could be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum, use of discovery depositions as substantive evidence in criminal trial. I have also had previously filed on July 10th of 2024, a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73, goes back to February 1974, Your Honor. What was particularly interesting about this case is the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying, and the witness repeating, my husband attacked me and I shot him, clearly beats the pants off of thrusting the hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Did I hear the citation again?
And I might remind the court, in addition to that, Miss Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Yeah.
Do you mind?
290 Southern 2nd, 73.
And I have one as well. I don't know if they want to hand it up now. I'll read it.
So this is what you just handed up?
Yes.
All right, I've reviewed Henry.
You want me to comment on Britain, case that they just provided?
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overt act, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britain case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britain's mind. I do believe that even if it's some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I could tell, from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence. And I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So we would object at this point.
Sir?
We expect to call and testify a domestic violence expert. That domestic violence expert is going to educate the jury, that he should educate all of us about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of the 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provide, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert is going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse, and you begin to develop a survival instinct for it. So that's why you employ the get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. that Ms. Benefield's concern, and the court may recall, it was the state that asked this question. Dr. Quintal, was Ashley Benefield concerned about the release of the Broder report? Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal, by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been in shock.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions. Some people call them spontaneous statements. And therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's a issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent substantial evidence that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well, the case law, and I also start with Smith, which I quoted in a prior order. And this is, again, Smith, 606 Southern 2nd, 641. And this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course, we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. Again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident, which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing. 577 Southern 2nd, 682. And in that situation, the evidence was kept out and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm, or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420. And this is at 422 and 423. It's first DCA 1996.
What's the oh my God about, Patricia? Did I miss something? I was looking down for a moment, and I've been listening. I didn't hear anything. Did Ashley do something weird?
Which is the defendant doesn't have to know about the reputation for violence, but here nor there. That evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence
Yeah, she does look.
And unfortunately, it doesn't give any indication about whether that was during the state's case in chief or the defendant's case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the
I
court?
guess you can ask, but I'm in the middle of a ruling.
Okay, well, I think it may be relevant, helpful.
Okay.
The court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay, so,
Right, and that's what I'm making my findings about.
yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt. And in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research. And this may be the case that ultimately, if it gets to the second DCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
Thank you.
Just, Judge, for the future, if in fact these WhatsApp messages do come in another way, we would also be asking for the rule of completeness, the rest of what was taken out.
Well, that's why I mentioned earlier, because you certainly, there may be other ones that you want to introduce.
Right. So I just to put defense on notice that may be an issue.
So we're going to bring the witness back in. And you can resume your cross.
Hey, Tia. Nice to see you. So basically what just happened there was they were talking about whether the messages talking about him punching a dog are admissible. And the judge basically ruled that the messages are not admissible at this time. But it was really interesting. Uh-oh. We have more going on here?
Judge,
Yes, ma'am. The witness is out.
I'm trying to interpret this as fast as I can, but this, then maybe the defense can confirm. I believe these are supposed Google searches or internet searches for certain subjects.
Yes.
That are on
Yes,
the
they're on
phone.
the phone,
And
that of which was extracted by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Can you give the judge the date of those?
The first one was, I'm sorry,
2020, Your Honor.
the first one was 5/11 of 2020.
So there, I'm gonna keep. I'm gonna keep talking until I feel like I see the jury coming in, because all of this is like wrangling. But so it was really interesting. I did not. It can't be called as prior bad acts, as it was never brought to the attention of the police or the courts. Right. So it was helpful how the judge explained that when there's an affirmative self-defense posture by the defense.
I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this coming in.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020. And the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Carter's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then again on 5/11/20, asked Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project, and 6 tips on 5/11/20 to help you co-parent with an abusive ex. So the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the break. Once the 9/11 tape came in, which said my husband attacked me and I shot him, together with the swollen eye and the scratches, as the case law says, I think that may certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing the murderous.
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not
Not
now,
yet.
No,
at this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position, except now the evidence is my position. Okay.
Watch the head swing.
Excluded.
I said not
Expressing the murderous.
You said I excluded them? I did not exclude them.
Did you see that
You're
head
not allowed
swing?
to
That was
introduce
a
them.
mean head swing.
Doing 5 months before she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. And I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response.
Judge, the reason this should not come in is the exact same reason that you just ruled on last issue. There are other reasons if it becomes relevant, if it becomes admissible, but that would be my reason.
Could I please see the exhibit?
Of course. Yeah.
So what I find difficult about this is that, do you know how many people are probably typing into Google at this very moment, co-parenting with an abusive ex, and they are the ones who are abusive and getting ready to accuse the other person of being abusive? So they're just looking up the different ways of painting somebody else as abusive. That could be their state of mind too. It could go to both states of mind. It could go to, I am really scared and I want to, I really am scared of this person. Or it could go to, I'm trying to figure out how to seem scared of this person.
And the purpose of offering defense exhibit 4A is to prove that Miss Benefield actually made those searches.
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
Previously, I had made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone. And the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. We still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Keeler. I would like to make a proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read defendant's Exhibit 2, or anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Keeler.
Can we just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh,
But if we could just make a copy and enter it.
we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I marked it as Exhibit 3, text messages, and it did not make it in.
Okay, yes. These are text from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer.
Correct.
Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that Detective Keyless would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would. Judge, I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes, sir.
Do you want Keyless to stay under subpoena? Because I want to give him the right instructions.
Yes.
All right, can you have Detective Keyless come back in? I'm so focused on getting his name right, I keep forgetting his title.
Judge, if it makes you feel better, it took us about 2 weeks to get it.
It just looks nothing like
so
that.
different.
That's why I didn't.
Sergeant, I'm sorry. Just right in front of him. Sir, at this point, the defense has no further questions for you, so I'm going to be able to let you go for today. However, you have not been released from your subpoena, so all the instructions I gave you regarding sequestration of witnesses still apply. You may not discuss your testimony or the questions asked of you with anyone, including the attorneys or other witnesses. You can't discuss with other witnesses what their testimony was or what questions were asked of them. And to the extent that this trial is being out there on the internet, you are not to watch or listen to anything related to it, including news reports. Do you understand? All right, sir, you're free to go now. If one of the parties calls you, you need to respond. Thank you. Oh, hold on. All right. Look, the clerk needs us to be clear on your proffer. Mr. Taylor, we have Exhibit 3, which is the
Text message.
the What's Now apps, WhatsApp messages. All right. That's document 3, but it's got multiple pages.
Yes, sir.
4A is not just 4A. It's 4A, 4B, 4C, and 4D. So we have
It's a composite.
composite 4 with A, B, C, and D. And then actually you had 5 was the Bible verse.
Yes.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all.
Thank you.
Do you want?
Well, I'd like to have it on there because
Stip.
they showed it, but they
Yeah.
showed it so
Stip.
quickly.
Oh,
Defendant's Exhibit 5, which is
sorry. Yes.
one of the I think this might have been the last one or one of the last ones.
Yeah.
All right. So there's a stipulation to the admission of Defendant's Exhibit 5. So that's in.
Thank you, Madam Clerk, for catching that.
Well, it's
Right. 5 is in. 3 and 4 are proffers.
when you exhibit 5 is in, for purposes of proffer.
No, for evidence.
Yeah, it's not going to do me any good as a single exhibit, Your Honor. I'd rather it be part of the composite. The court's ruled that it's not admissible.
No, I'm ruling 5 is admissible
Okay.
because it was shown. State you showed it.
Right, it was shown.
So this is just a printout of.
Well, okay, but I think he hasn't. Do you want it admitted?
The witness is gone.
So maybe 5 should just be with the composite number 4 and not entered. Just give the as a proffer.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then. All right. All right, so you ready to call your next witness?
Yes.
Ready to bring the jury in?
Yes.
All right, let's bring him in.
And I think we are going to use maybe just open the blinds, but.
So I just typed a couple messages into the chat, but in case you didn't see them, I'm not a big fan of like talking about other channels and their coverage of these cases on here. I don't get after subscribers for doing that because it's not that big a deal, but I usually don't engage in the conversation that much. But I am curious about a few of you have actually said that there are some popular channels who are championing Ashley, which is of course their right to do. And I have no problems with channels wanting to, take a side of the case. I'm just super curious which channels are championing. I've got there. How?
All right, you all can have a seat. Welcome back, everybody. Did anybody begin deliberations amongst yourselves, talk with anybody outside of the jury about the case, or do any research, or hear anything about anything you talked? We're last here, Detective Keelis had finished his testimony, and now we'll let the state call their next witness.
Stay with call Dr. Vega.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Hello, sir. I'm Judge White, I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Get about 12 to 15 inches from the microphone. It just does adjust up, down, left, and right as you need. Speak in a loud, clear voice. We should hear everybody.
I will. Thank you, Your Honor.
Good afternoon, doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the Chief Medical Examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
Here, so October 1st will be 21 years.
And you said here, were you a medical examiner somewhere else before?
I was an associate medical examiner in Hillsborough County for 4+ years.
And what kind of education do you obtain to become a medical examiner?
Well, I mean, it's different from person to person a little bit. I can tell you my own personal experience.
Yes, please, yours.
Certainly. So I did my undergraduate studies at Florida State University. I majored in physics and biochemistry. After my undergraduate, I went to medical school at the University of South Florida. I graduated from medical school in 1990. Following that, I did 2 years of training in general surgery and then 4 years of training in anatomic and clinical pathology. Pathology, it's a specialty of medicine that focuses on how to diagnose diseases based on looking at cells, fluids, tissues, biopsies, organs, and by doing autopsies. Finally, after all that, I did a 1-year fellowship in forensic pathology. That's the subspecialty which really focuses on performing autopsies and doing death investigations.
Thank you, sir. And what are your current duties as a chief medical examiner, or at least, yes, as a chief medical examiner?
So as the chief medical examiner, I administer the office here. So I manage the staff, I set policy, do procedures, and I do some of the casework myself. So I do some of the autopsies and death investigations.
So you do still conduct autopsies regularly?
I do.
And do you know how many approximately autopsies you've conducted in your lengthy career?
I don't know exactly. I suspect it is getting close to 4,000.
And of those, can you have any involved gunshot wounds?
Very many of them.
And so that was my next question. The percentage, do you think it's a lot?
Yeah, I can't tell you the percentage, but I've examined many hundreds of gunshot wounds.
Thank you, sir. And I'm going to draw your attention back to September of 2020. Did you conduct an autopsy on Douglas Benefield?
I did.
And when did you do that?
The autopsy was performed in the morning of September 28th of 2020.
And can you explain how your procedure for conducting an autopsy?
Certainly. And I don't think my procedure is greatly different from other medical examiners or forensic pathologists. But the procedure starts with the examination facility where the autopsy is performed. That includes documenting the condition of the body with photographs and diagrams and written notes. Following that, if there's reason for evidence collection, and typically that's going to be in concert with a law enforcement agency, then evidence collection ensues. After the initial part of the examination and the evidence collection, then there is a more detailed examination looking for identifying characteristics, changes that might represent natural disease, and then any injuries that are present. After all of that, then I think what many people might consider the traditional part of the autopsy begins, which is the internal examination, where the body is examined internally for, again, the same kind of changes of injuries and natural diseases.
And is that the process you followed in the autopsy of Mr. Benefield?
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
Yes.
Dr. Vega, I'm showing you what's been pre-marked as states 86 through.
Can I see the photographs, please?
Yes, the same as the one you just looked at. That.
So there's 3 photographs, Your Honor, that I have an objection to.
Okay.
More exhibit objections. Okie dokie. You know what that means? Do you know what that means? It's sidebar show and tell time. We're having a show and tell sidebar with Janet's art. And I have the volume on, so we'll be able to hear when they start talking again. Here's Janet, some of Janet's art, everyone. Solo's art. I really like that. She's taking up some painting. Good friends are like stars. You can't always see them, but know they're always there. Very true. Do not disturb. I like the colors on that and the animals. I really, really like this. Is that you drawing that? Because that's really cool. Talking.
She's going to put them back in order for me while we do that. During your autopsy, did you determine the height and weight of Mr. Benefield?
I determined the height and the body length, as that's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
That was 169 pounds.
And the length?
The body length was measured to be 69 inches or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you. Sorry, Judge, just bear with me one second. Okay, we're gonna try this one more time. I'm gonna show you 86 through 97. Would you mind taking a look at those photos and telling me if you recognize them?
So I think I might have glitched out earlier when I was saying this. A couple of you have been talking about other channels that are big popular channels that are big time on Ashley's side. I'm not a big fan of talking about other channels while I'm live. Not that that it bothers me a lot when other people do, but I just don't. But I'm really curious what popular channels are.
Yes, I do recognize them.
And are the, and what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you, Your Honor. At this time, I'd ask to enter states 86 through 97.
No objection.
Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them up here in just a moment.
Okay.
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Oh, okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. The chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there any, and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin and the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's been marked as states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time, the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows the projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance one would be?
Certainly.
Thanks, sir. And where would the exit one be?
Well, no exit, but
I'm sorry, the projectile.
projectile,
Yes, sir.
my mobility is limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal.
Yes,
It wasn't front to back like it went straight through. Can you describe it?
certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you. And you said that it struck his ribs and his lungs and his vertebral.
His vertebral body,
Thank you.
The
So
spine.
his spine.
yes,
And would that injury have been immediately fatal?
probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes, what one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then you said he was also shot in the leg. Is that correct?
That's correct.
So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's excuse me, the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different
And how so?
because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by a defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast moving awl or punch, in that it goes in and it almost drills a hole into the skin. But when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 that correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's correct.
And I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf. And then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect, injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out. And that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Hard to see. Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
So on me, the entrance was here
If it would help, I could put my finger there.
and the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left and from back to front. Yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that I've made you get off the stand.
Entrance. Lodged bullet.
Would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see both of those demonstrations?
Yes, Judge White, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg injury?
Yes, sir.
Yes, there was.
And I'm going to show you states 15. You'll take a look at that and tell me if you recognize it.
Yes, I do.
And how do you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter states 15.
So, Judge.
Received.
Thank you. And Dr. Vega, I have a photo of states, this is states 97. Is that the same item that is in states 15?
Yes.
Thank you. Did you find any, I'm going to go back to well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And What, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
Well, the absence it reflects the same principle in either injury. And what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case. But any more precise determinations require the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle. So would that mean that if it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
And I know you determined a path of travel and we're still talking about the leg injury, for this leg injury, but does it tell you, this path of travel, anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated, because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And Your Honor, may I have just one moment?
Yes.
Dr. Vega, if hypothetically Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell, when you conduct an autopsy, and specifically in Mr. Benefield's, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And was there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
I don't have anything else, Dr. Vega. Thank you. The defense may.
Mr. Taylor Cross, and of course, the question is, do you need this?
I do not.
You've got a powerful soul going there. That's a very powerful soul.
Yes, sir.
Very
Good afternoon,
sulky.
Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice. Thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct. Yes.
Muscular build.
I don't think I use that terminology. I think I just talked about the weight and the body length.
I want to ask you, you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, that's, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3 foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge, beyond his expertise.
That's
I'll
a
allow
legal.
if the witness has the knowledge to answer.
In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
Objection, close for legal.
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because I asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
Let me just check, Your Honor. I think that might
Yes, sir.
conclude. Last question with respect to the leg. You've told us that the gun would have had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Baker.
State, any redirect?
Yes. Dr. Vega,
I don't want it to be unclear. The gun would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered, or the front of him. It entered through the side.
Yes, so the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go.
Thank you, Your Honor.
Oh, General, we're switching. Could the deputy pass 14 and 15? Would you mind?
Oh, pass, you mean,
Yes.
to the jury?
Sorry,
I wasn't
publish.
quite sure what you meant.
Sorry,
Publish.
I meant pass through the jury. Yes, sir.
All right. Members of the jury, as with yesterday, we're to pass these around. These will go back with you during your deliberations. All right, state, your next witness.
Daniel Hausdorff.
face the clerk. Madam Clerk, sorry, are you sure what you said or not?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Hello, sir. How you doing, Judge? My name is Judge Wright. I'm presiding over this case. As the deputy said, just make yourself comfortable in that chair. Scoot up just a little bit. I'd like to have you about 12 to 15 inches away from that microphone. It does adjust up, down, left, right as you need. And if you just speak in a loud, clear voice, it should pick up everything.
Yes, sir. Thank you.
Good afternoon.
Good afternoon.
Could you state your full name?
Hold on one second.
Oh, I'm sorry.
Go ahead. You all finish up. So we're gonna wait a second.
Yeah, I apologize, Judge.
I don't want anybody to feel rushed. But and like I said, everything will go back with you all during the deliberations.
Thank you.
All right, Ms. Friel.
Thank you, Judge. Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorff.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I am a crime laboratory analyst in the firearms section.
And how long have you been in that position?
I've been in that position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test the firearms as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there. I'm sorry. What kind of training did you receive to become a firearms analyst?
I have a bachelor's degree in biomedical science from the University of South Florida. I was hired at FDLE in September of 2013 as a forensic technologist in the firearms section. That had 6 months of training, and I was in that position for about 3.5 years. I then was promoted to analyst and completed the 18-month training program to hold that position, and have been out of training since August of 2018.
Thank you. And do your daily duties include the analysis of firearms?
Yes, ma'am.
And have you previously testified as an expert in the field of firearm analysis?
Yes, I have.
Thank you. And can we just talk about ammunition first to kind of get the basics? What do you call a complete item of ammunition?
A cartridge.
And someone might refer to that as a bullet, but that an intact live round.
Yes, ma'am.
Okay, so you use the word cartridge.
Yes, ma'am.
And what are the components of a cartridge?
A cartridge is comprised of 4 parts. There's the cartridge case, which is the body of the cartridge. There's also the primer, the gunpowder, and the bullet.
And the bullet might also be referred to as?
A projectile.
Thank you. And does your analysis also regularly involve the analysis of semi-automatic firearms?
Yes, ma'am.
And can you tell me what a semi-automatic firearm is?
A semi-automatic firearm is a handgun that is going to fire one shot every time you pull the trigger, and the gases for firing is automatically going to cycle the firearm, extracting and ejecting a cartridge case and automatically loading another cartridge.
And so the cartridge case leaves the firearm every time?
Yes, ma'am.
And that's opposed to a revolver, is that right?
That's correct.
And I want to draw your attention to FDLE case 311227, the case you're here about today. Did you have the opportunity to examine evidence submitted to your lab under that case number?
Yes, ma'am.
And when you receive evidence into your lab, what's the normal procedure?
The normal procedure is the agency will submit the evidence to our lab where it's given the unique FDLE case number, and then each item has a unique FDLE item number. It's given a case tracking form, which I receive from my supervisor when I'm assigned the case, and that has all the details of the case. And everything is tracked in our computer system called LIMS. It's the Laboratory Information Management System that just keeps all the information about the case and the evidence, where the custody of all the evidence is being held at that time, and things like that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence.
It's open. Would you take a look at that and tell me if you recognize it as an item you received in your lab?
Yes, ma'am.
And what is it?
It's the Springfield Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FTLA case number, item number, and my initials in my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block. All are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
It's empty.
Well, I was gonna say there's gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorff,
Yes, ma'am.
would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then like the gunpowder, which is going to cause those rapidly expanding gases to propel the bullets down and out of the firearm. But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it will go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thank you, sir.
I'm sorry, Mom. Can we further for a moment?
Of course.
So I've been perusing, around, and I noticed that this person actually makes a very good point here on the artist formerly known as Twitter. This person says Ashley Benefield will testify, and they're not saying they're not announcing anything. This is their opinion because they're saying that Judge White's rulings are basically forcing the messages we want to get.
Mr. Hausdorff, if we heard testimony that when this firearm was found, the slide was not totally seated, does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank you. And how do you know these are items you previously examined?
They all are marked with the FTLA case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed in which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test to test, and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there just
Yes,
so we
ma'am.
can talk about that part?
Yes.
We're really going. And so you said you first look at test to test. And can you explain slowly
Yes,
how what you're looking for to compare those to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you looked at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10. And 14. Would you like to take a look at these items?
Yes. Thank you.
And tell me if they're items that you've previously seen in your lab.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullet as well as the weight. And if I have both of those, that'll already give me my answer like that. And in this case, all 4 of these projectiles were intact. So I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in 45 caliber class.
And that's the same caliber as the casings and the firearm, is that correct?
That's correct.
And what type, other than the weighing, the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all 4 of these bullets were fired from this firearm.
Now, I think the first time you said fired in and then you said fired from.
The
What's
reason I
the
just say in is that cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical.
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that it was no value for microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received 1 t-shirt, and what I will do is I will visually, microscopically, and chemically test the t-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the t-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was unable to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is States 2. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
Gunpowder.
Thank you. And when you examined this shirt, did you find any of that?
No, ma'am.
And did you make any other observations, that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual t-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
Yes.
I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross.
Very briefly, so Mr. Houseworth, your testimony here today is basically that
The ammunition was fired from that gun in this case,
Yes, sir.
and you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Leroy,
No, sir. Thank you.
can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're released from your subpoena. You're free to go.
Thank you, Judge.
Thank you. State,
Your Honor, at this time, let's take rest.
all right. Members of the jury, The state is rested, so there's a couple of legal things we need to speak about. So I'm actually perfect time for your afternoon break. I'm going to give you 15 minutes. So remember, please don't discuss the case amongst yourselves. Please don't do any research on the people, places, things, or legal topics you've heard anything about. Don't speak with anybody else outside of the jury about this case at all. All right? Leave your notes. All right, you all can have a seat. All right, when I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea before I let them go for the day. I saw the looks. All right. So the state is rested. Obviously, we have a number of things we got to do. First and foremost, the JOA. I'm just surmising that it's going to be a lengthy JOA argument. So we got to get through that. Now, depending on what the ruling is on that, we also, if I do deny it, I want to talk with Ms. Benefield about my colloquy regarding testifying or not testifying. It won't be to get answers at this point. It'll just be the colloquy that I go through. I'm looking back to my notes. We've still got the issue of Vicki Mechanic, trial sub, and Richardson hearing. We've got the issue of Daubert and what's his name? Bliss? The expert. Ferris. I don't know where I got Bliss.
He's a police officer.
You smushed them together.
Okay. We've got that. And I have another Richardson issue. It just says 391 emails. Okay, Richardson emails.
All right, y'all. I'm gonna mute this while they talk through this housekeeping business. So what the state has rested, interestingly, I am definitely much more convinced than I ever was. Now that I've seen the state's case, I'm more on the side of guilty than not guilty. That's where I'm at. But I'm also open to hearing the defense's case. It was really interesting to learn. I didn't understand this before, but we always learn new things, right? That when you put forth as a defendant a affirmative self-defense, the way the trial works is that the burden of proof beyond a reasonable doubt is on the state to when they're doing their case in chief. But when the defense gives their case in chief, then the burden switches to them to prove their case, right? So I didn't know that the burdens moved around when there was a specific type of defense. And then the burden moves back to the state when they go to their rebuttal. And So it's really that helps me understand the whole trial process a lot, because that was confusing me. What you see a lot happen a lot in these cases, like with Karen Reed and like with this one, is they start adjudicating things that don't have to do with the crime, but have more to do with the defense, because of what the defense is posturing as their defense theory, right? So, anyway, then it comes down to the question: is she going to testify? I think she is going to testify,
And then we can hit the ground running tomorrow morning. Just so you know, because as soon as I said tomorrow morning, it was in my head. We could still start at 9. I'm open to that. But I will have a hearing at 8:30 because I've got motion for release of uncharged defendant, 33-day motion. I'll have to hear first thing if it hasn't been obviated by the filing of the information or a null clause. I don't know yet.
getting the timing.
And that's scheduled for 8:30?
I set it for 8:30 tomorrow. I asked for it to be set for 8:30. So you all take your break, and then I'll see you back here in about 12 minutes.
Thank you.
So, not entirely sure what time they're going to start tomorrow, but I'll keep an eye on that. But I think she's going to testify, and the judge's rulings almost force it, because they're not allowing in this evidence that they keep wanting to bring in about his previous abuse. And so the only evidence that they're going to have that he was ever physically abusive, as she claims, is her testimony, because there's no other evidence of it. It has to be her testimony, and it has to be her testimony is the only way that they will be able to talk about that he shot a gun into the ceiling or punched a dog. That's the only way that's going to be able to come in. So she's most likely going to testify, and that will probably be tomorrow. And then it's a question of, do they put her on first? And what I've noticed is when a defendant testifies for themselves in a murder case, in a lot of times they put on when the defense takes on their case, they usually call the defendant first to get through the timeline and things like that. And then they bring in the expert witnesses to confirm or expound on what the defendant just said, to, validate them. So we'll see. It should be an interesting day tomorrow. But I'm going to end for today. And if anything more exciting happens in court today, then we'll pick it up. We'll see it tomorrow, or we'll highlight it tomorrow. Please remember to hit the thumbs up. Thank you very much for being here. As usual, when I share my links, do not feel obligated. It's just another way to support the channel. I want to show one more thing. I don't know if Solo is still here, but I want to show one more piece of art that she shared with us. Let me take my banner down here. And it's clearly a tribute to her late son. Remembering Jordan David Smith, just 27, a heart so huge, a soul from heaven. His love for family, friends, and Jesus was strong. In his presence, joy flowed strong. And was strong in his presence, joy flowed strong. Talented in sports, but skating held his thrill. Fishing, quiet waters, a passion he fulfills. His mom's embrace, a hug so dear. In its absence, sights of love appears. Three sisters now wander lost in grief's haze. His absence is a void and their hearts in a daze. Yet Jordan's spirit is bright and true. He shines on forever in skies of blue. That's beautiful solo. Rest in peace to Jordan, continuing rest in peace. And it gives you a sense of the hurt and the pain and the feelings that parents go through when they lose their children. And I know there are other people in here who have lost their children as well. And my heart goes out to you as well. It is my deepest fear in the entire world is one of my children leaving this world before I do. So I have an immense amount of compassion. And I guess that's another reason I'm so drawn to cases about children. When you love, children are so amazing and such, bring such hope for the future. And when adult human beings just trample on them and ruin their lives, it kills me. It just sickens and kills me. They're innocent. Anyway, I could go on and on, but I will see you all tomorrow. Please remember to hit the thumbs up and I'm sorry. I hate to make you bawl, Patricia. But hugs to all of you. And I will see you all tomorrow. Bye.